Sorry, we're late. We received an email with a different starting time.
That's okay, no stress. Glad we're all here now. So is this team six? Is that correct? You guys team six.
Yes.
Great. And so you guys are the defendants?
Yes, that's right.
Great. So senior counsel, is that you, Declan?
Yes, that's right.
Perfect. And then junior counsel, we've got Oliver Colshaw. Perfect. So on the Jessica, we've just got Jessica to join. You're going to be on our judging panel too. Is that right, Jessica?
Oh, yeah.
Perfect. So Estee and Jessica are also on the panel of judges today. So you guys could get questions from any three of us. Um, and all the best for you all today. Let me know if you guys have any questions before you get started. Obviously, at the end of the day, this is, I know it's a competition, but do enjoy yourselves as you're going along. Really, it's just practice and training for your advocacy. So take it easy on yourselves. And we're asking questions because that's what we're meant to do. So not to scare you or throw you guys off too much. Okay. So enjoy it. I'm not sure if any of the other judges want to say anything before we get started, but yeah, do any of you guys want to say anything?
No, very well said, Zeina. Thanks.
Perfect. Cool. So I'm just going to have a timer next to me, but I'm not going, for example, to knock or anything to say, oh, 5 minutes left. It's just going to run for 30 minutes. But I expect you guys to keep up to time, obviously, because you've got a junior counsel as well speaking. So just make sure you're managing your time properly. So once the time is up, I'll just say time is up. And obviously, then you guys will get a right of reply at the end. So let's start then. We've got team seven, and I'll start by taking appearances.
May it please the court, Nefra Chanda, and I appear as senior counsel for the plaintiff with my learned junior Vanessa Markon. We will each speak for 15 minutes and I'll have a further 2 minutes in reply.
May it please the court. My name is Declan Sullivan, and I appear alongside my learned junior Oliver Colshaw. We'll both speak for 15 minutes with a 2 minute rebuttal as well.
Thank you, counsel. You may commence.
May it please the court. I will address submissions 1 and 2, dealing with procedural fairness issues, and my learned junior will address submissions 3 and 4, dealing with the human rights issues that arise. Your Honours, the plaintiff is not an average public housing tenant. She's a 9-year-old child of the Wurundjeri Woiwurrung people with severe cerebral palsy and autism. She lives in a home uniquely suited to her needs, close to medical facilities and an Indigenous community centre. She's surrounded by her Indigenous community, with whom she shares strong community and kinship ties. Moving her risks severing her from her support networks and causing lasting harm to her well-being. We seek declarations that the demolition decision was invalid and unlawful. We also seek an injunction restraining the defendant from taking any further steps to demolish the towers without consulting her family and or her community. I'll move on to my first submission now. The test for whether the common law implies a duty to observe procedural fairness was established in Kiowa and West, which was decided in 1985 in volume 159 of the Commonwealth Law Reports at page 550. Your Honours, may I dispense with formal citation?
Yes.
Thank you, Your Honours. There, Justice Mason held at page 584 that where a decision affects a person's rights, interests, or legitimate expectations, that's when there is a duty to be heard. Subsequent authorities have clarified that legitimate expectations themselves are not sufficient to attract procedural fairness, but the High Court appears to have broadened the rights, interests, legitimate expectation test in more recent cases. So, for example, in WZARH, the court held that in the absence of a clear contrary legislative intention, administrative decision makers must accord procedural fairness to those affected by their decisions. Disorganized developments, the court held that presumption of procedural fairness applies to any statutory power which is capable of having an adverse effect on legally recognised rights or interests. So, Your Honours, while legitimate expectations themselves are not recognised as a ground, as something which attracts procedural fairness, much rather, the test is much broader than what it used to be. I'll proceed on to whether the duty to afford procedural fairness to the plaintiff was excluded in this case. Section 15 of the Housing Act does not expressly exclude procedural fairness. We acknowledge that there was a very similar case, which was Bourke and Holmes Victoria, in which Justice Richards found in that case that Holmes Victoria was not obliged to give the plaintiff an opportunity to be heard before making the demolition decision. But Justice Richards did not say that there could never be that an exercise of powers under Section 15(1)(a) could never be conditioned on procedural fairness. Precisely what Her Honour said at paragraph 110F is that whether the exercise of the power affects legally recognised rights and interests turns on the nature and circumstances of the decision rather than the nature of the power.
So, Counsel, how do you say we should distinguish this case from that one?
There are a number of points, Your Honour. For one, the plaintiff in that case had a mild disability, so he had mild cerebral palsy. In our case, the plaintiff has severe cerebral palsy. She also has strong kinship ties to the land, which the plaintiff there did not have. And this all goes to the rights and interests aspect of the test. Your Honour, would you like me to perhaps address that part of my submission to fully answer your question?
Yes.
So, like I submitted earlier, the question now is whether there is a sufficient interest of a party, and that would ground an obligation to observe procedural fairness. So, the demolition decision in this case would severely affect X. Now, this is in a very different way that it affects other people in the housing tower and other people in the broader community. For example, I would direct your honours to the report completed by Dr. Prudence Malatesta, specifically at subheading 5, which states disproportionate impact of relocation. There, Dr. Malatesta addresses she's addressing the disproportionate impact of relocation and identifies a few people or few classes of people who would be disproportionately affected. For example, she notes that there would be increased social isolation, particularly for children, the elderly, and people with disabilities. There would be the disruption of cultural connection, especially for Aboriginal and Torres Strait Islander communities who rely on proximity to kinship networks and cultural institutions. And there would be reduced access to local services, including health services and disability supports. Your Honours, the plaintiff does not fit into just one of these categories. She fits into all of these categories. So the decision affects her in a much more direct way than it did to the plaintiff in Bourke, for example. Your Honour, may I be on for further assistance on this point?
No, you can continue.
Thank you, Your Honours. I'll move back to earlier in my submissions. I will address the urgency aspect. So the housing crisis has existed for a considerable time. In some cases, the court has held in situations of urgency, public authorities may not need to afford the same level of procedural fairness. However, the housing crisis has existed for a long time, as was the case in McWilliam, because it's existed for months, if not years. This is not the kind of urgent situation which would justify exclusion of the procedural fairness rule. In addition, the very fact that this decision had some policy and political considerations also does not exclude the obligation to observe procedural fairness. This is, for example, illustrated in cases like FAI insurances. Now, the question then becomes, if we find that if we find that the Homes Victoria did have an obligation to observe procedural fairness, who did they owe that obligation to? So we have to identify who are these classes of people that they had to give a hearing. As I submitted earlier, the report submitted by Dr. Malatesta states that certain people would be disproportionately affected and more affected than other people. X is a person who fulfills all of these criteria. So she is statistically in a very small percentage of people living within the towers who would be affected to that extent. So she stands in a class of her own, Your Honours, and that's why you should find that there is an identifiable class in this case and a class of people who should be afforded procedural fairness. With respect to X's community, they are defined as...
And so just on the topic of procedural fairness, are you saying that she should have been consulted, or in what way would there have procedural fairness been carried out?
Your Honour, she and her community should have been consulted, but they should have been allowed to make representations about how relocation, or how much rather the redevelopment decision would have affected them. So in that regard, I might refer to disorganised developments, specifically around paragraph 44, where the High Court held that there was no reason to doubt that an owner or occupier in that case may have something to say of relevance about the characteristics of the land or its uses, or about possible adverse impacts of the decision there. So likewise, in this case, it's very difficult to say that the plaintiff and her community could not have said something about the effect that this redevelopment or demolition would have on them. They should have been given the opportunity to talk about, for example, why they needed to be in this specific tower community, why this might not work if they were relocated somewhere else. They should have been able to make submissions on those issues which directly affected them.
And counsel, are you saying that the duty to consult her, where is the source of that duty? It's not in the Housing Act. Is it an implied duty or in a charter somewhere? Where do you say is the source of that?
Well, Your Honour, again, that would be essentially, I think what Your Honour is asking is, what are these rights or interests that ground this procedural fairness duty? Again, those rights and interests are, for example, the plaintiff's human rights, which my learned junior will address. So these human rights were considered in TIO as something which grounded procedural fairness. They also, another example of rights that are affected is her community's cultural rights and ties to the land and their kinship networks. So when these people have a legitimate expectation, or they have enjoyed the benefit of living close to these community centres or maintaining their community ties, when they've experienced that for so long, they are entitled to make submissions, for example, when that situation is going to change. So in FAI insurances, for example, Justice Mason held, paragraph 360, that procedural fairness was afforded where, for example, a person was being deprived, a decision deprived a person of a legitimate expectation in circumstances where it would be not fair to deprive them of that expectation without a hearing. So the plaintiff has made modifications to her apartment in reliance of her continuing residency in that apartment. She has developed a strong community in that apartment. These are all examples of benefits that she and her community expect to continue, and that's why they should have been consulted on this issue. So in addition to human rights, I'll quickly address the situation with TIO. Now, in that case, the High Court held that the decision maker had an obligation to consider the human rights instruments and or much rather the plaintiff in that case, they had a legitimate expectation that the decision maker would consider the human rights instruments. Now, TIO has been doubted in other cases because, for example, the court has found that human rights instruments are not necessarily part of law until they're ratified, for example. But in our case, there is the Charter of Human Rights. So that's a very different situation to what happened in TIO, and that actually strengthens the human rights arguments in the sense that it makes a stronger argument for procedural fairness arising from human rights. There's also, for example, in Nicholson in New South Wales, Justice Badgery Parker found that since one of the purposes in the Act in that case, which also, that case also involved a public housing tenant, and the court there held that one of the purposes of the Act was to confer security of tenure upon public housing tenants, and that gave rise to an expectation that tenure in those houses would continue. In our case as well, Section 6, subsection F of the Housing Act says that one of the objectives of the Act is to promote security and variety of tenure. Now, if that was capable of grounding an obligation to observe procedural fairness in Nicholson, Your Honour should find that there's no reason why this case should be considered differently, notwithstanding what Justice Richards held in Bourke, noting that that related to a different factual situation. I'll quickly summarise my second submission, and that's that Homes Victoria failed to give the plaintiff and her community an opportunity to be heard. Homes Victoria did not ask the plaintiff or her community about the impacts of relocation. They didn't ask them about the impacts of demolition. They haven't yet confirmed that the plaintiff and her community will be able to stay together following relocation. The plaintiff and her community could have made submissions on all of these issues, and they were denied the opportunity to do so, and that is why Homes Victoria failed to observe procedural fairness in this case. Unless I can be of further assistance to Your Honours, my learner junior will now present submissions 3 and 4.
Thank you.
Your Honours, I will now turn to submission 3 of our written memorandum to discuss whether the decision unlawfully or unjustifiably limits the plaintiff's rights under the Charter of Human Rights and Responsibilities Act. The defendant, Homes Victoria, is a public authority under Section 4 of the Charter. Section 38(2) requires public authorities to act compatibly with the Charter. We submit that the defendant's decision to demolish the North Melbourne Towers infringes upon the following 3 rights of the Charter. Section 13, right to privacy and reputation. Section 17, right to the protection of family and children. And Section 19, the right to cultural rights. I will speak to each of these rights individually. The scope of these rights should be identified broadly and not legalistically, focusing on the right's purpose and the interest it protects, as per the case of Crackle and Mental Health Review Board, reported in 2009, volume 29 of the Victoria Reports, starting at page 1 at paragraph 97. Your Honours, before I continue with my submissions, may I dispense of formal case citations?
Yes.
Your Honours, any of these Charter rights may only be limited as per the proportionality test in Section 7(2) of the Charter, which assesses the importance of the purpose of the limitation and the consideration of less restrictive means. Expert evidence from Professor Jessica Guan at page 15 of the bundle of documents, specifically paragraph 18, confirms that retrofitting offers a less restrictive means which is reasonably available to achieve safety and amenity improvements, and the retrofit can be staged and targeted, reducing disruption to residents compared to wholesale demolition. ultimately preserving these established communities within the towers and limiting the severe social dislocation that accompanies dispersal. I will return to this point throughout my submission. The defendants will argue that retrofitting was not feasible, as it was too costly, disruptive, and unable to fix core deficiencies. However, this was a conclusion Alexander Garg, the CEO of Homes Victoria, came to, an individual with a vested interest in advancing the demolition and opposing retrofitting. We respectfully ask this court to consider the findings of Professor Jessica Guan, a structural engineer with over 20 years of experience, who conducted an independent report and indeed found that retrofitting constituted a less restrictive and reasonably available means of improving the towers. Hence, we submit that any limitation of the following charter rights is not justified under Section 7.2. The first right engaged by the demolition decision, Section 13, protects against the arbitrary or unlawful interference to a person's home, privacy, or family. I will first discuss the question of what constitutes a home. In Director of Housing and Sudi, the respondent sought to resist an application for possession of public housing premises by the director, on the grounds that it would breach his right to have his home unlawfully or arbitrarily interfered with. The respondent was not the tenant, but the son of the former tenant who had died and had resided at the premises for substantial periods of time. Bell J, in this case, held at paragraphs 22, 32, 94, and 124 that the respondent, despite occupying the premises unlawfully, had a strong and genuine connection with the place over a long period of time, and that the director, in seeking to evict the respondent, breached his rights under Section 13A. Although this decision was overturned on appeal, Your Honours, this point was not considered by the Court of Appeal. Hence, home is a question of fact and is dependent upon sufficient and continuous links with a place. X has grown up in these towers. X's modified apartment provides safety, support, and a sense of belonging. These factors correspond to this strong and genuine connection that was recognised as central to the concept of home in Saudi. X's home is more than just a physical place, it is integral to their well-being and their rights. However, Section 13 also requires this right to a home to be arbitrarily interfered with. Your Honours, may I seek leave to rely on a case which is not in my written submissions? I can provide the full case citation and note that it is in our learned friend's written memorandum as well.
Yes.
Thank you. In the case of Thompson and Minogue, the Victorian Court of Appeal at volume 358, paragraph 55, held that an arbitrary interference is one which has resulted from conduct which is unpredictable, unjust, or unreasonable in the sense of being proportionate to the legitimate aim sought. We submit that the decision to demolish is unreasonable to the legitimate aim sought. The aim of the demolition, as the defendants will argue, is to provide tenants with safer and higher quality housing. To achieve this, Homes Victoria does not need to displace an entire community or knock down these towers. Retrofitting is an option which can solve the issues within the towers, as I submitted.
How do we know that retrofitting is an option? Obviously that the towers currently they don't seem to meet the current standards for safety. So while I can understand, obviously, it's going to be a huge issue with the relocation, I mean, I'd rather the residents be safe. Don't we want to prioritise that?
That's correct, Your Honour. We are not submitting that there aren't problems with the safety and accessibility of the towers. There indeed are, and they have been found by multiple reports. However, in order to improve the safety and accessibility of these towers, there does not need to be a demolition, as was found by Professor Jessica Guan. There can be structural remediation which can address these core deficiencies and issues of the towers, and this can be achieved through a retrofitting.
What exactly does Professor Guan say on that?
On which point, Your Honour?
on the fact that demolition is not necessary?
Professor Guan says that demolition is necessary and can achieve the same means. In her report, she concludes that the retrofit can be staged and targeted, and that specifically at page 19, she states that the retrofit can be done through replacement of windows, upgrading fire safety through modernized stairwells, sprinklers, and smoke management systems, reconfiguring internal layout to improve dwelling amenity, and modifications to meet contemporary accessibility standards, such as widening corridors and doorways. And she states as well, at paragraph 11, that these measures would directly address many of the deficiencies identified by Homes Victoria as the rationale for demolition.
Okay, thank you.
Council, I had a follow-up question on that. It seems that the plaintiff's submissions are focused heavily on the fact that, on the submission that retrofitting is a feasible option, unlike in the case of Berry. My question for you is whether or not that forms the ratio of that case, and whether or not, I think more importantly, that would have affected Homes Victoria's assessment of whether they would have gone ahead with the decision anyway.
Could you repeat your question, Your Honour? Are you referring to the case of Berry, specifically in this case? Sorry.
Yes, so my question is for you, the plaintiff, whether or not the fact that retrofitting is an option would have affected Homes Victoria's decision to go ahead with the demolition anyway.
In this current case?
Yes.
Yes. In section 32(1) of the Victorian Charter states that, and this is my submission for, but I will address it now, Your Honour, that the ordinary meaning of a provision should be determined by exploring all possible interpretations and adopting one that least infringes human rights. So here we're looking at section 15(1)(a) of the Housing Act, which grants Homes Victoria the power to develop any land and hence to demolish the towers if they think that is the correct decision. However, this section in the Charter states that the greater the infringement of a proposed interpretation from the Charter, the stronger the preference for an interpretation consistent. And this is from the case of Director of Public Prosecutions and Victoria, which was decided by the High Court. So here we are submitting that since Section 15 grants Homes Victoria a broad power to develop any land, and there are no restrictions to this power, this needs to be interpreted through in a way that is consistent with human rights as per the Charter. And that is a way being consistent with human rights, considering other alternatives to develop this land, and not just considering the alternative of demolition, because that is the most right-infringing interpretation of that section. And hence we are submitting that a different interpretation of that section would be to consider alternatives such as retrofitting, which is less right-infringing.
Thank you.
I will now turn to section 17, which is the second right engaged by the demolition decision. The concept of family, this section seeks to protect families and children, is broadly interpreted and recognises the diversity of families that live in Victoria, all of whom are worthy of protection. This is per page 14 of the explanatory memorandum of the Charter. This broad interpretation encompasses diverse family structures, including Aboriginal kingship systems. This is a point that my learned leader spoke about, and Aboriginal peoples, they hold these cultural kinships, which are different to the Western nuclear model of family. And hence, Your Honours, it is pivotal to understand the vital role of extended relationships in supporting and sustaining Aboriginal individuals. And hence, this concept of family, as is protected by Section 17, ought to be construed broadly in the case of Aboriginal peoples. Further, Section 17(2) of the Charter requires consideration of children's best interests, consistent with Article 12 of the United Nations Convention on the Rights of a Child, which recognises that children need special legal safeguards. X's views on their best interests should also be given due weight as per the purposes of this section. X has stated that the demolition decision is against their best interests. Specifically at page 19 of their affidavit, they've stated that moving will mean losing their daily support they receive from neighbours, friends and extended family, and moving will disrupt their access to doctors, therapists and other essential health supports located near the tower. Your Honours, also the case of Director of Housing and Sudi at paragraph 1 held that the eviction of people residing in public housing is a severe infringement of their rights which protect a family and home. Hence, we submit that Section 17 has been interfered with as a result of the demolition decision. The third right engaged is Section 19, which is in relation to cultural and religious rights. Specifically, Section 19.2 recognises Indigenous peoples' relationship with the land and the maintenance of their community ties. The United Nations Right Committee at General Comment number 23 regarding the International Covenant on Civil and Political Rights held that the positive right is protected in Article 27. Article 27 is the article that relates to Section 19 of the Charter. The committee observed that this article requires the relevant authorities to take positive measures of protection against state interference. We submit that this positive right has been interfered with. The loss of community and place directly undermines X's ability to maintain their cultural practices, which is the very harm Section 19.2 seeks to protect. This is also a distinguishing factor from the case of Berry, given that Berry was not an Indigenous person and hence Section 19.2 did not apply in that case. The defendants will argue that X will continue to be able to be a part of their community despite not living with them. However, Your Honours, it is important to note that X has limited mobility, is on a wheelchair, and hence geographical proximity to their community is pivotal in maintaining those community connections. Hence, Your Honours, we submit that the demolition decision infringes upon three distinct rights, Section 13, Section 17, and Section 19. Even if it were found that only one of these rights is infringed upon, specifically Section 19 as it relates to Indigenous persons, this would be sufficient to find incompatibility with the Charter. Your Honours, may I seek 2 minutes of additional time for speaking?
Yes, I'm happy with that.
Thank you, Your Honour. I will briefly turn to my second submission, which I have already discussed in response to Your Honour's questions. And I just wish to point the court's attention to two more international materials which may aid in interpreting this charter. As I submitted Section 32 of the Charter, specifically Section 32.2, stipulates that international law and judgments of domestic, foreign and international courts that are relevant to a human right may be considered in interpreting a statutory obligation. In relation to the International Covenant on Economic, Social and Cultural Rights, General Comment number 7 on Article 11.1 of this covenant clarifies that forced evictions are prima facie incompatible with the requirements of the covenant. It defines forced evictions as permanent or temporary removal against one's will from the homes or land which they occupy without the provision and access to appropriate forms of legal or other protection. The general comment also notes that women, children, youth, Indigenous people, ethnic and other minorities, and other vulnerable individuals and groups all suffer disproportionately from the practice of forced eviction. X, as an Indigenous child with disabilities, is precisely within the scope of these disproportionately affected groups. Your Honours, in the consideration of time, I will not discuss any further international materials, and hence we submit that Homes Victoria has failed to act compatibly with these international obligations, and we respectfully seek that the court finds that the decision is incompatible with human rights. Thank you.
Thank you, Mr. Sullivan.
Your Honours, the case before you today concerns a decision to demolish the North Melbourne Public Housing Tower and redevelop it. And the reason for this decision was because after decades of repairs to this building, it was no longer considered feasible to continue the band-aid solutions of repairing the building. It was no longer up to minimum livability standards. Homes Victoria made the decision under Section 15, subsection 1A of the Housing Act to redevelop the North Melbourne Public Housing Tower. One of the tenants is the plaintiff, who is a disabled Aboriginal child. She and her family are concerned about the separation of their Aboriginal community as they relocate before the redevelopment is finished. The key issues which come from these facts is whether the lack of consultation with the plaintiff's family and or her community reached an obligation to hear from them prior to making this decision, and whether there was any infringement on their human rights. Your Honours, I will address the issue of procedural fairness and specifically whether an obligation arose for Homes Victoria to hear from and consult with the plaintiff's family and or community prior to making the decision. My learned junior will address grounds 2 and 3 of our written submissions, which deal with the issue of human rights and whether the decision infringed on the plaintiff's rights under the Victorian Charter. Your Honours, turning to the issue of procedural fairness and whether there was an obligation to hear from the plaintiff's family and or community, I'm going to divide this up into 3 separate sections. Firstly, whether under the common law, an obligation to hear from the plaintiff's family and or community arose. Secondly, whether under statute, an obligation to hear from the plaintiff's family and or community arose. To both of these points, we submit that there was no obligation. But finally, in the alternative, I will address that even if there was an obligation, the decision would not have realistically been different as a result of following this obligation, and therefore the court should not intervene to try and alter the outcome of this case and reverse and possibly impose an injunction on the redevelopment decision. So turning to the first point of whether there was an obligation to hear from the plaintiff's family and or community under the common law. And our learned friends have submitted that the common law has developed. Firstly, it started in the case of Kiowa and West, which was reported in 1985 in volume 159 of the Commonwealth Law Reports at page 550. And Your Honours, may I dispense with formal citations for myself and my learned junior?
Yes, Counsel.
So the case of Kiowa is our starting point for where a common law duty may arise from. And in that case, at page 584, Justice Mason stated that procedural fairness is required where rights, interests, or legitimate expectations are either directly or immediately affected by a decision. Our learned friends have then directed the court towards later cases, including the case of WZARH. And in that case, which was a High Court case in 2015, the court stated that procedural fairness is required and attached to decisions that affect rights and interests of individuals. By the court not stating that rights and interests must be directly or immediately affected, it could possibly be inferred by that case that there has been an implied overruling of the Kiowa requirements for a direct interference with rights when we are going to look at whether procedural fairness, and in this case, an obligation to be heard, is required. However, the law has developed further since that case of WZARH. Instead, we get to the 2023 High Court authority in the case of disorganised developments. And Your Honours, if I can take you to page 584 of the case of disorganised developments at paragraph 33, Chief Justice Kiefel and Justices Gagler, Gleeson and Jago stated that when a statutory power is exercised, procedural fairness is ordinarily attached to that power. However, there was a condition and a qualification upon this, and that was that procedural fairness, in this case an obligation to be heard, must still be consistent with the historical scope of the duty. In this case, we turn back to the case of Kiowa, where it was stated that there needs to be a direct effect on rights. And this was restated in paragraph 33 on page 584 of Disorganized Developments. It was restated that there must be a direct effect on rights and interests when we are to impose an obligation to, in this case, hear from certain people as part of a broader obligation to afford procedural fairness. And so the common law has evolved to the state now where it is a requirement that rights must be directly affected if there is to be this common law obligation to afford procedural fairness, and in this case, an obligation to be heard. And so we need to now apply this principle of direct effect on rights and interests and see, was there any direct effect on rights and interests in this case? And to that point, we submit firstly that there was no effect on rights or interests as a result of the decision. And secondly, that even if there was an effect on rights and interests as a result of the decision, that this effect was indirect. And so turning to that first point of whether rights were affected at all by the decision. And to this point, we submit that the decision itself is merely a preliminary decision. It's a signalling of future intent to redevelop the North Melbourne Public Housing Tower. And the decision itself does not remove tenants from their homes. And the decision itself does not therefore affect their rights. Just off the basis of this decision, the tenants cannot be forced out of their homes. And the reason for that is because a possession order under Section 322 of the Residential Tenancies Act can only be sought if a notice to vacate has been issued. And the prerequisite to issuing a notice to vacate under Section 91ZY subsection 1B of the Residential Tenancies Act is that all the necessary permits and consents must be acquired. And so the decision itself,
isn't
yes,
it
Your Honour.
isn't it enough that it could affect their future rights and interests? I mean, it's good that we're at the stage of the preliminary decision. I mean, I don't want it to be where it's already caused all this significant impact and harm. We're trying to put a stop to it before that happens.
Your Honour, we submit that there will be harm in the future. However, that harm isn't derived from the decision itself. It's derived from the steps taken after the decision to give effect to it. At this stage, the minister could very well change policy and decide not to redevelop the North Melbourne Public Housing Tower, in which case the status quo would remain, in which case we would see that the tenants' rights are not affected at all. The decision itself has not impacted the tenants' rights. And the reason we can say that is because if the decision were taken away at this stage, they're still in the same position. Decision or not, the position of the tenants remains the same. And this is consistent with Justice Richard's reasoning at paragraph 114 in the case of Berra. But
So
Your
what
Honours, if
just to confirm, what you're saying is that it's not currently affecting any rights or interests. So there's no jurisdiction to act on it right now?
that's correct, Your Honour. Because the rights have not been affected by the decision itself, which is what this court has been directed to look at and examine, then there is no obligation to hear from the plaintiff's family and or community arising from, again, the decision itself. But even if you're unconvinced by that submission,
If procedural fairness only arises at the eviction stage, then isn't it too late for residents to influence the redevelopment outcomes?
we submit that procedural fairness doesn't only attach to the eviction itself, but it's the steps taken to give effect to that eviction. And the decision is categorized as a signaling of future intent and policy, but it's not itself an active step to give effect to what the ultimate policy is, which is redevelopment. Those steps are later on. But Your Honours, if you're unconvinced by the submission that no rights are actually affected by the decision itself, well, then it turns to the question of, if rights are affected, are they directly affected? And to that point, we submit that they are not. And again, turning to the case of Berra, and if I can take Your Honours to paragraphs 110 and 111 of Justice Richards' judgment. It was stated that the exercising of power under Section 15, subsection 1A of the Housing Act was a power directed at redeveloping land, a power directed at redeveloping buildings. It was not a power directed at individuals. And Justice Richards stated that the impact on individuals under the exercising of this power is indirect, and it comes only from their attachment and their connection to the land which is being redeveloped. And so, consistent with the reasoning in Berra, we submit that there is no direct effect on these tenants at the very least, and therefore the common law obligation, which requires a direct effect on individuals, has not been invoked, and there is no common law obligation to hear from the plaintiff's family and or community as a result. Your Honours, if you have no further questions about the common law duty, I'll turn now to whether there is both a statutory obligation but also an international obligation to hear from the plaintiff's family and community.
No further questions.
So our learned friends have submitted that international obligations have given rise to an obligation to hear from the plaintiff's family and or community. And they've submitted the case of Teo in relation to this. And the case of Teo dealt with legitimate expectations derived from international instruments. But as our learned friends also submitted, legitimate expectations no longer form a basis for an obligation to provide procedural fairness, and in this case, to hear from the plaintiff's family and or community. So an international obligation may give an expectation to people that certain actions need to occur, but the legitimate expectation aspect of the common law duty to provide procedural fairness has been since abolished and overruled in cases such as disorganized developments. And therefore, no international obligation gives rise to an obligation to hear in this case. Your Honours, even if we now turn to the case of a statutory obligation and assess if there is a statutory obligation at the very least which gives rise to an obligation to hear from the plaintiff's family and or community. A statutory obligation may arise, or the argument would follow, that in being directed to consider the objects of the Housing Act in exercising the power under Section 15 of the Housing Act, Homes Victoria was under an obligation to follow each of the specific objects outlined in Section 6 of the Housing Act. One of those obligations, as submitted by my learned friends, was that there is an obligation to ensure security of tenure. However, security of tenure was not found to be threatened by the redevelopment decision in the case of Berra, and that can be found in paragraph 114, subsection B of Justice Richards' judgment. Moreover, in the case of Berra, in Justice Richards' judgment in paragraph 110, it was stated that Homes Victoria has a wide discretion in how it exercises its authority under Section 15, and it has a wide discretion in how to consider the different objects of the Housing Act. And it has a discretion in how to weigh up the different objects. And so it's difficult to reconcile this judgment that Homes Victoria has a discretion in how to pursue the different objects with the Housing Act with a separate submission that they're actually under an obligation to follow the specific objects within that same act. If they have the discretion to pick and choose and weigh up these objects,
Counsel,
how could they also be under an obligation? Yes, Your Honour.
So why should we follow Berra? Are we bound by it? And what is it about it that makes it why we should follow it?
We submit that Berra is highly persuasive for a couple of reasons. The facts are strongly analogous to the case at hand. It concerns, again, a decision by Homes Victoria to redevelop the exact same building, the North Melbourne Public Housing Tower. And it's also a case heard in the Victorian Supreme Court earlier this year. And so the recency of the decision, the court in which it was heard, and the analogy of the facts are the reasons that we submit that Berra is highly persuasive on the court today.
Counsel,
Your Honours,
are the defendants conceding that it is not binding but merely highly persuasive?
yes, Your Honour, that's correct. Your Honour, in the interest of time, may I seek leave for a further 2 minutes to address my final point of whether an obligation, if it were heard, would realistically change the outcome.
Yes, just 2 minutes. Yep.
Thank you, Your Honours. So even if there was an obligation, which we submit there was not, to hear from the plaintiff's family and/or community, what would this obligation actually look like? And the obligation itself to hear from these people would see Homes Victoria perhaps sit down with them and discuss the decision and how it may affect their rights, or how these people may be concerned about the impact of the decision. However, the effect of the decision and the concerns of the tenants have already been considered by the decision maker, in this case, Mr. Garb. And so it's very difficult to see how reconsidering issues which have already been considered through a consultation process would realistically change the outcome. And finally, it's important to also note that this decision has not just been made to fix up the safety of the North Melbourne Public Housing Tower. It's important to note that this decision was also made in line with broader policy considerations, namely the need to alleviate the housing crisis by increasing housing for 20,000 people. And this overarching policy consideration suggests that even if the tenants were consulted, even if there were an obligation to consult with them, this overarching policy consideration, coupled with the fact that the effect on their interests has already been considered, demonstrates that there's realistically not going to be a different outcome in this case. Your Honours, for these reasons, we submit that the plaintiff's claims should be dismissed and no injunctive relief should be granted. I now defer to my learned junior to address grounds 2 and 3 of our written submissions.
May it please the court. I'm going to address the issue of human rights, specifically whether Homes Victoria's decision was an unlawful and unjustifiable limitation of the plaintiff's human rights under the Victorian Charter. I shall address this question in 3 points. First, whether the rights under the Charter were interfered with. Second, if the rights were interfered with, was the interference justified under Section 7.2 of the Charter? And third, what consideration should be given to international treaties and obligations when considering if the rights have been limited under the Charter? In assessing whether rights have been limited under the Charter, the starting point for the court is to look at what rights have been interfered with. And our learned friends have raised in their submissions that the rights under Section 13A, Section 17 and Section 19 have all been limited. And whilst we do not concede that each and every right was infringed upon per paragraph 7 to 10 of our written submissions, we do submit that there likely has been some limitation or interference with the rights contained under Section 8, so it's like Section 13, 17 and 19. Regardless of what rights or how many rights may be interfered with, the crux of this human rights issue is whether Homes Victoria was justified in interfering with these rights in applying Section 7.2. So Section 7.2 states that a human right may be subject under law only to such reasonable limits as can be demonstrably justified in a free and democratic society based on human dignity, equality and freedom. And this provision lays out the factors that are to be considered in making this assessment of whether a decision is justified in limiting rights under the Charter. The main factor in dispute here is Section 7.2e, whether there were any less restrictive means reasonably available to achieve the purpose that the limitation seeks to achieve. We submit that there was no less restrictive means reasonably available to achieve the purpose that the redevelopment decision seeks to achieve. The purpose is to remedy serious life, safety, structural and accessibility defects in a mid-century tower now well beyond its life and unfit for modern habitation. And second, to increase the social housing supply on the estate in the face of a housing crisis. Now, whilst retrofitting and other alternative options do exist, we submit that they would not have any meaningfully lower impact on tenants that the redevelopment option would have, and it would not achieve the objective of the redevelopment program as effectively and to the same extent as redevelopment would. Mr. Garg's statement clearly states that there is no less restrictive means available, and he is reliable by virtue of his position. If I could turn your honours to paragraphs 52 of the case of bearer, the exact same position, a chief executive officer for the exact same public authority body, Homes Victoria, was sufficiently qualified, given that position, to express the opinions in the issue. So therefore, Mr. Garg is appropriately experienced to express opinions about the management of ageing housing stock. And by virtue of that position and him considering alternatives and weighing them against the concerns of the known hardship of relocation, which is the evaluative balance is set out in his section 8 of his statement. It was not a rushed nor dismissive of residents' interest, but it was reflecting a responsible discharge of a statutory function in the face of a public need. And as Justice Richards observed at paragraph 227 of bearer, and that was applying the rationale in Thompson and Minogue, paragraph 75 to 77, decision makers are not required to prove a negative by disproving every conceivable option. What matters is that alternatives were considered and rationally rejected. And that occurred here.
Can I pause you right there? You mentioned earlier that, well, you submitted that Mr. Gart's statements essentially should be elevated above the experts' statements in relation to the feasibility of retrofitting. Is that your submission?
Your Honour, we submit that there are conflicting statements from two professionals, and not trying to discredit present company, but even if we accept Guan's statement that the alternatives, those alternatives would still not achieve the objectives that the purpose of the limitation seeks to achieve, which is the relevant factor under section 7.2e. And the purpose is to make more safer accessible housing stock, which are, we do submit that retrofitting would not be viable in the fact that the constraints are tied with the very buildings themselves, as well as the fact that we are in a public housing crisis and that retrofitting, renovating, redeveloping the land would increase the capacity threefold and add tens of thousands of additional dwellings. That's the purpose that the limitation seeks to achieve. So if we were to accept that Professor Guan's alternative was a feasible option, it still does not achieve the purpose.
Thank you, Counsel. A follow-up question as well, in terms of the qualifications that Alexander Gart holds in comparison to Mr. Newport in the case of Berry, in the paragraph that you cited, 52, do you have any submissions as to whether or not they are analogizable or at least comparable to qualifications that they hold? Because I know that in that case, Mr. Newport actually does have specialized knowledge of asset management in public housing sector.
Beyond the fact that they are both chief executive officer of the same body, Homes Victoria, and the court did accept that was sufficient in terms of the role. We can concede the point that given there is no knowledge as to any as to Mr. Garg's relevant expertise, given his qualifications, but it can be presumed that given that he is the chief executive officer of Homes Victoria, he does meet the requisite requirements to express opinions on the matter. Given the constraints were inherent to the buildings themselves, the narrow corridors, the undersized rooms, and the low ceilings and the lack of balconies, they cannot be merely fixed by retrofitting. If the goal is to meet all contemporary accessibility and safety standards without having to strip the entire building down to its skeleton anyway, retrofitting every single deficiency that Mr. Garg did present. He did present an array of deficiencies, and Professor Guan identified as well, across every critical dimension of modern housing: the seismic and structural integrity, the fire safety, the accessibility, the thermal performance, waste, recycling, amenities. Retrofitting all of those deficiencies would be, in truth, redevelopment in any case, just in substance, under the guise of retrofitting. The ship of Theseus, if you will. It would be replacing everything that redevelopment would in substance, without the benefits of redevelopment being realized, which is namely a layout that's truly code compliant and up to modern safety and accessibility standards. And again, that genuine uplift in social housing supply of thousands. Given,
are you submitting that retrofitting is an alternative to extending the life of the towers? Are you conceding that it is an alternative?
We submit that it is an alternative, but it's not. It's too restrictive under Section 7.2e. It does not achieve the purposes of increasing housing, nor does it truly. It would not truly meet the needs to meet public. To meet the needs of modern public housing. That is our submission. And that point, the point on public housing cannot be understated, because Victoria is facing a profound housing crisis with thousands of families languishing on waiting lists. And the Charter does not operate in a vacuum. The rights of current tenants must be balanced against the rights of those without any home at all. And because redevelopment would increase capacity and add thousands of additional dwellings and deliver secure, dignified housing for those in need, as well as current tenants, it is therefore we submit that what occurred here was a rational, evidence-based assessment of the options under Section 7.2e, and no less restrictive means were reasonably available at this time. Other factors to be considered are the importance of the purpose of the limitation. And in this case, it is justified because it does serve that larger goal of the housing crisis and ensure current tenants and more Victorians as a whole will have access to safe, sustainable, and high quality housing, as well as the extent of the limitation that needs to be considered under Section 7.2c of the Charter. And in this case, the limitation on rights is only temporary, as tenants will have a chance to return to the North Melbourne housing tower after its redevelopment, per Mr. Garg's statement. Additionally, the household level consultations in and as such, the interference with the plaintiff's rights, whilst not insignificant, will be reduced significantly by the ongoing consultation process, and will be an interference that is only temporary and that ensures the plaintiff's housing situation for the future is markedly improved. And for these reasons, we respectfully submit that Homes Victoria was justified under Section 7.2 in limiting or interfering with some of the plaintiff's rights under the Charter. I shall now turn to international obligations. First, there has been no violation of international obligations. And second, if there had been a violation of international obligations, this can only inform a violation of a right under the Charter, and will have no effect on the outcome of this case, as we have submitted that any interference with the charter rights was demonstrably justified under Section 7.2. So Section 32.2 of the Charter, as my learned friends have raised, makes clear international law may inform the interpretation of charter rights, but this alone does not create any freestanding cause of action. The court's task is not to enforce treaties directly, but to interpret the charter rights in their light. And so against that framework, the relevant instruments that do come into light are the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Importantly, my learned friends have raised the United Nations Declaration on the Rights of Indigenous People, which affirms Aboriginal people's cultural rights and their connection to lands. And whilst important, these instruments are broad and aspirational, and they do not prescribe that dwellings are to be maintained in perpetuity, nor do they prohibit redevelopment when that redevelopment does aim to improve safety, habitability, and accessibility. And on these facts, Homes Victoria's plan to redevelopment is not in tension with these instruments, but rather it advances them, because the decision to demolish and rebuild aims to secure adequate housing that enhances safety and the dignity for its current tenants, and expand access for many more Victorians, and which is fully consistent with international obligations to progressively realise adequate housing. And in regards to their Indigenous rights, relocation can still occur on Wurundjeri country as it's a vast country. Kinship ties can be supported through cluster relocations and chances to return. The community facilities aim to be rebuilt, relocated. The decision ultimately does not sever cultural connection. It's rather trying to sustain it in safer conditions. Accordingly, Your Honours, to contend that contemporarily displacing X with a guaranteed right of return to a fully accessible building in which corridors and common areas and facilities will now all meet modern disability standards, as opposed to just her apartment per her Section 6 of X's affidavit. That's flawed, because expanding her autonomy and her ability to engage with kin and with community to a greater extent, that's doing the exact opposite of what my learned friends contend. In the interest of time, I'll just conclude. For the reasons submitted by my learned leader, that Homes Victoria was under no obligation to hear from the plaintiff's family before making the decision, and for the reasons I've just submitted, Homes Victoria was justified in its actions insofar as they infringed on any rights under the Charter, and we respectfully ask that the court dismisses the plaintiff's claims.
Thank you, counsel. Right of reply.
Your Honours, our learned friends have heavily relied on one single case, the case of Barrett, for their arguments. I wish to point once again the court's attention to the factual differences from this case and the case at hand. Firstly, Barrett is not binding due to the decision being held by one single judge. Secondly, as already submitted, X is a child who has severe cerebral palsy, whereas in Barry, the plaintiff only had mild palsy, and X is also autistic, unlike Barry. Further, there is the issue of X being an Indigenous, or the factor of X being an Indigenous person. Richards J. in Barrett at paragraph 114C found that Barrett's interest in preserving the community was not a legally recognised interest for procedural fairness purposes. This is what our learned friends have submitted. However, in our case, Section 19 of the Charter meant that the plaintiff had a legally recognised right in preserving their community. Specifically, Section 19.2 states that Aboriginal persons hold a distinct cultural right and must not be denied that right with other members of their community. This is a positive right. Further, in Barrett, the Homes Victoria CEO had special qualifications which enabled him to express opinions on the options available regarding the public housing towers. This is specifically at paragraph 52 of Barrett. Alexander Garg does not have any relevant qualifications, and neither he didn't consult an expert to complete an independent assessment regarding the retrofitting or feasibility study, and hence this would be needed to come to the conclusion that retrofitting is not available, as it is a decision that Alexander Garg himself came to. Further, in regards to the statement of Professor Jessica Guan, our learned friends have stated.
Thank you, Council. That's time.
Thank you.
Yes, right, a reply.
Your Honours, the factual differences between the case at hand and Berra have no meaningful impact on the outcome of this case. Just because the plaintiff is an Aboriginal child with disabilities may mean that she is affected to a greater extent by redevelopment than the plaintiff in Berra. But this does not mean that she is now affected directly by the decision. And so, under the matter of procedural fairness, just because the effect may be greater does not make the effect direct. As a result, there is no obligation to hear from the plaintiff which arises by virtue of a greater impact on her than in the case of Berra. The second point is the qualifications of Mr. Newport in the case of Berra and Mr. Garg in the case before the court today, and whether that will have an impact on the human rights discussion. Even if we accepted Professor Guan's evidence on the viability of retrofitting, Professor Guan's statement does not speak to increasing housing supply, and moreover, we submit that the extensiveness of the retrofitting required would also mean that it would be a costly exercise that would not meaningfully be less restrictive and would also not achieve the additional goal of increasing housing supply. So for these reasons, whilst there may be some factual differences between the case of Berra and the case before your honours today, these differences will not have any effect under the matter of procedural fairness because there is no direct effect on the plaintiff, and it will have no effect under human rights because the alternatives in this case will still not be less restrictive or achieve the full purposes of the redevelopment decision. Thank you, Your Honours.
Thank you. Okay, everyone, I think that's the end. Well done to you all. I hope you're all feeling very relieved to be done with that now. Good job. That was really heavy. You all got questions from basically all of us, and you handled that really well. It's a lot of pressure in the moment to answer questions, not knowing what to say, where to go with it, but you all did a fantastic job. It makes sense why you're all in the semifinals, basically.